Hey guys, it's me again. Welcome to my YouTube channel. Please kindly like, subscribe, and follow for more. Today, I've invited Miss C. Mazwati, a law student from Africa University in Zimbabwe, once more to talk about the law of evidence. However, we are mainly focusing on the witness competence and compellability, which is under the rules of trials. By the way, you should note that the law of evidence governs the proof of facts in the court of law. So, Catherine, please kindly give us a brief background and introduction about the rules of trials.
Thank you, Tadiwa, for having me once again. Okay, as you have requested, I'll start with an introduction. What you have to understand is that the most vehicle of proof is evidence, and the term evidence can be defined as an item or information proffered to make the existence of a fact more or less probable. So, in line with this view, you have to appreciate the importance of a witness as one of the forms of evidence. Do you understand?
Yeah, I do.
Yes. So a witness plays a very important role in criminal cases as they help to clarify relevant information about a crime. And in Zimbabwe, every person is competent to be a witness unless the rules provide otherwise. So, what you have to understand is that the general rule is that all witnesses are both competent and compellable. Competent meaning able to provide evidence, and compellable meaning liable to be required to give evidence. Do you understand?
Yes, I do.
Okay, so as you have required and requested, I'll move on to give you a brief background. So, you should bear in mind that just like any other jurisdictions, Zimbabwe has its own rules of trial that have to be adhered to by every court of law. These rules are mainly found in the Constitution of Zimbabwe, proving that the Constitution of Zimbabwe is supreme and is the backbone of every law, including law of evidence. Do you understand?
Yeah, I do.
So, the first rule that is important to note is the rule of trial, which is stated in the Constitution of Zimbabwe. So, the Constitution of Zimbabwe lays out the rules of trials noted in Section 69 of the Constitution, which provide that a person charged with a criminal trial has the right to a fair trial by an independent and impartial not. Do you understand?
Yeah, I do.
Yes. So, what you have to understand again is that the general rule in Zimbabwe is that during a trial, a person must be allowed to call a witness, and witnesses are questioned so that they bring out evidence, as I have explained in the introduction.
Yeah.
Okay. So, when parties are represented by attorneys, the attorney will question the witness to extract their testimony. Do you have any questions?
No, not yet. You can continue.
Okay, so the evidence of certain class of witness is insufficient standing alone as proof. So typically, such witnesses as conspirators, young children, and complainants in sexual cases need to be corroborated. So, corroboration is the term used to describe evidence that is consistent with the witness account of the events and tends to support the status case. Do you get it?
Yes.
So, I'll start with the cases where there's one witness. So, in cases where there is only one witness to the crime, certain special evidential rules apply. A single witness could or might not be a suspect witness. The court must follow the particular guidelines for single suspect witness. So, in order to determine whether it is safe to convict based solely on the testimony of the witness, it is imperative to thoroughly evaluate the witness's credibility and dependability. Do you understand?
I see.
Yes.
Yeah.
So in the case of Nduna and another, the court decided that inconsistencies in the witness testimony are not always fatal when a conviction depends on their witnesses. Okay, Tadiwa, do you have a question?
Yeah, I would like to think so. I've understood what you were mentioning in the previous discussion. So I would like to ask on this question: are there any cases on single witnesses?
Yes, there are a lot of cases on single witnesses. Like I've mentioned earlier, there's a case of Nduna and another. And another case is the South African case of Mukwena. So it was established in the South African cases of Mukwena that an corroborated testimony of a single witness should only be relied upon if it was clear and sufficient in all material aspects. Do you understand?
Yeah, I do.
Okay, so as I have explained earlier, children can also be competent witness. So I shall begin my explanation. More so, when looking at children as competent witness, it is imperative for one to note that there is no statutory provision that governs the capacity of children in relation to giving evidence. Do you get it?
Yeah, I do.
Yeah. In line with this view, young children may be permitted to testify, provided they approach the duty to speak the truth, have sufficient intelligence, and can communicate equally. Do you understand?
Yeah, I do.
Okay.
Makes sense.
So,
Alright.
do you have any question?
In light of what you were saying, how is the court expected to approach the evidence provided by children?
Okay, so in line with the question, the court must approach the evidence provided by children with caution because, according to Beck J.A., children frequently have active imagination and have a propensity for fantasizing. So in the case of Mutasa, H.H. 52, the judge emphasized that the testimony of young witness must be treated with caution. And the caution must be creative or positive, using the knowledge of related fields such as psychology to maximize the significance of the testimony. Do you understand?
Right. Yes, I do.
Yeah. So you have to understand that in civil proceeding, a spouse can also be a competent witness. Apart from civil proceedings, a spouse can also be and is also a competent witness. Yeah. So I'll explain. In civil proceeding, a spouse is both a competent and compellable witness. In criminal proceeding, a spouse of the accused is a competent witness for the defense, whether or not the accused is charged jointly with another person. Do you understand?
Yeah, I do.
Yeah. So for the prosecution of the wife, the spouse of an accused is a competent witness, but cannot be compelled to testify, except they are testifying against crimes like rape, aggravated indecent assault, and other criminals. I'll explain them later.
Interesting.
Okay, so the court must also approach the testimony of accomplices with caution. An accomplice is a person who has assisted or participated in any commission of a crime. Do you understand?
Yeah, I do.
Exactly. And you get why the court should treat the evidence with caution.
Yeah, true. I get it.
Okay, so the court stated that in case of Mamoche, that a witness is a qualified, that an accomplice is a qualified witness as long as he is not a co-accused who is being treated in the same case. Should I move on?
Yes.
Okay. Oh, before I forget, do you have a question?
Yeah. Are there any witnesses who are considered as incompetent and compellability?
Yes. In line with your question, I'll proceed. However, a person who is not unable to effectively communicate with the court is not a competent witness. Have I answered your question?
Yeah.
Okay. So if one is unable to comprehend the proceedings in the court and to respond to questions appropriately, such a person is to be deemed as an incompetent witness. Do you get it?
Yeah.
So in accordance with the section 246 of the Criminal Procedure and Evidence Act, it says, no person appearing to be afflicted with a mental disorder or defect shall be competent to give evidence while such under that influence. Meaning to say that a person should not be under the influence of alcohol and other substances like drugs and stuff. So a person should be able to comprehend the proceedings of the court for them to be a compellable and a competent witness. Yes. Do you have any questions?
Do you mind telling us about your sources of information? They do really sound interesting.
Oh, thank you so much. So from this presentation, the sources that I used were the Constitution of Zimbabwe. I think I mentioned the rules of trial. Yeah, that one I got it from the Constitution of Zimbabwe. I also used the Criminal Procedure and Evidence Act. Mind you, when I told you about the people or the type of witness that are incompetent, I referred to section 46 of the Criminal Procedure and Evidence Act. I also used the act, and since I used a lot of cases, I used Zemli. On Zemli, you can access Zimbabwean cases, case law, yes, and on Safli, you can access South African case law, like I've just read, yes. And I also used Murphy on Evidence 5th edition. Yes, this is the other source of information that I used.
That's great. That's a great research work you put in, and thank you for the effort.
Yeah, thank you for inviting me to be here. It's such an